I'd like to start by thanking the Chairman Coons and Ranking Member Tillis for having this hearing because, as everyone has acknowledged, the Supreme Court decisions in Mayo and Alice have really created a mess relating to patent eligibility, and the hope for this the hope is that this legislation will provide some level or a lot of predictability to the patent system. So having said that, though nothing is ever particularly simple, and I did write down that Mr. Iancu said that the manipulation of nature by human beings should be patentable. That sounds very reasonable. Mr. Johnson, I think you mentioned that a lot of things can be eligible, but that doesn't mean that a patent will be forthcoming. So would you say that regarding what Mr. Iancu said, that should be patentable, that goes to eligibility, that doesn't necessarily mean that a patent will ensue?
Absolutely. It may be that the manipulation is not new. It may mean that it's obvious and not worthy of patenting, or it may be that the invention isn't described pursuant to the requirements of Section 112, and so it may fail for other reasons.
So this is, thank you, because that's what is eligible to be patented. I want to make clear it doesn't mean that a patent will ensue. There are other factors that the Patent Office will
Absolutely
consider. Question for Ms. Brinkerhoff and Mr. Blaylock. So some critics of this legislation, notably the ACLU, argues that it would allow patents for human genes and other natural materials. Proponents of the bill respond that it explicitly makes ineligible patents on unmodified human genes and natural material. But critics reply that there is an exception making eligible any gene or natural material that have been isolated. Question to both of you. What are some examples of genes or natural materials that you expect to be patent eligible under this legislation and that are not eligible currently?
I'll start and I'll leave the genes to you.
Ms. Brinkerhoff?
So some examples, as I mentioned, are isolated. When you discover a chemical from a plant that could have use as a therapeutic agent, that would be a natural product that cannot be patented now, that would be restored to eligibility under PIRA. Other examples are the bacteria that I discussed, where the bacteria may be found in certain areas of the world, like cold-tolerant bacteria may be found in the North Pole, but those are found to have specific useful properties that make them useful in industrial applications, and those would be restored to eligibility under PIRA that cannot be patented now.
Mr. Blaylock, do you think that is reasonable, that the items that Ms. Brinkerhoff has mentioned should be patentable?
I don't, and if I may, I'd like to extend this to the concept of genes, which you also asked about, and to use that example, that if one were to observe newly a particular genetic mutation that is associated with a disease risk, that the question is, how would PIRA make that patentable? Because the only thing that is new is that knowledge. Because isolation, purification, and enrichment are ordinary aspects of conventional genetic sequencing technology. So one would take a blood sample from a human, take an off-the-shelf commercial aluminum machine, and it would isolate, purify, and enrich that gene, and the PIRA would allow patenting that would stop the exploitation of that new knowledge. There is no other human involvement in that other than recognizing the knowledge.
Ms. Brinkerhoff, would you like to rebut?
Thank you. Yes, I think he underestimates the inventive contribution of figuring out that there is a new gene with a new purpose, a new function that hasn't been discovered or known before. So I think that is an inventive act that warrants patent protection.
That's why things are not simple. But I think we all agree, at least, that the current situation is a mess. So I agree with that. Thank you, Mr. Chairman.